Good morning, ladies and gentlemen. Welcome to another episode of Property Law Alliance with myself, Chuma, Bruno Simao of Bruno Simao Attorneys, and Nick Brodie of SSLR. Today we've got quite an interesting question, and it's quite lengthy as well. So what we will do is try to break it down bit by bit, and we'll have both attorneys give answers interchangeably as we go through. It is coming from a Mr. or Miss Anonymous, but I'll try to summarize it as best as possible. What happened is basically they bought a property on property 24, they say, from an estate agent who's been selling homes for quite some time. The property was in the estate agent's and owner's name. So it's the same person. The estate agent is also the owner, and they were selling then the property. And they filled in all the necessary details in the sale agreement, including the mandatory disclosure form as the representative property practitioner. Right. And what then occurred is that important to note is that the mandatory disclosure form only filled in one item, not working in the kitchen. Right. And then what happened is that after taking occupation, the purchaser then realized that there were quite a number of defects. One that were actually amounted to quite a huge amount, to the tune of almost R1 million. And also the certificate of compliance was fraudulent. And then what the purchaser then did is then obviously try to approach the agency to assist them with this issue. And upon approaching the agency, she got told that no, the estate agent is actually acting in her own personal capacity, who's also / the seller. And there's nothing that the estate agency can do, and the principal as well. So in a nutshell, then the question then becomes, also important to notice that the same transfer attorney firm that handled the transfer on the house is now the official legal representative of the estate agent, which is then obviously acting as opposition of the actual purchaser. The questions then become, in short, is that what sort of remedies from almost any angle or all the angles can the purchaser have against the seller, number one, who is a registered property practitioner, and number two, the estate agency itself. So a number of things to then we can look at. Maybe Bruno and Nick can assist us with the agencies, any remuneration involved, the cancellation, So basically, in short, that is the question.
Cool.
Yeah.
Cool. Should I get started?
Yeah, please. Yeah. It is quite lengthy, but we will debunk some of the details as we go along.
Sure. And I think Nick is going to agree with me on this. So if we try to shorten the question, there's certain fundamentals that need to be answered, and the rest of the stuff is just detail. It may be crucial, maybe not, depending on the fundamentals being answered. So the reality here is a property was bought by from a seller, as one normally would buy. Mandatory disclosure form wasn't correctly completed, and now there's defects. And what happens with what happens now? Like what recourse does the purchaser have? So that's the fundamental that goes down the middle of this question. Now, ancillary issues that we need to start looking at is, but what capacity was the agent acting in? Did the agency give authority to the agent to act in that capacity? Is there any way to hold the agency responsible, notwithstanding? And it's a completely different legal argument, because there's facts that would have to be proven in order to actually be able to do that. So it is possible to break this question down into those type of components and then kind of take it from there. So at the fundamental level, you're looking at a seller-purchaser transaction and defects later found. So first thing that you want to start looking at now is look at the contract. There's the first protocol. What does the contract say regarding defects? If the contract speaks about defects and things like footstuds and things like and that sort of thing, certain rules would apply to that. Typically, what you find is defects that are known to a seller. So known defects that are not disclosed are almost on it's tantamount to fraud. So irrespective of whether a contract has a footstoots clause or not is irrelevant. If the person doesn't disclose something that they knew they should have disclosed, it almost comes down to fraudulent behavior. And the purchaser would have recourse against the seller in those instances. If, however, obviously bearing in mind that this is a mandatory disclosure form that was completed by the seller, the reality behind it is they did not disclose everything, but did they know about it? Very, very, very different story. If they didn't know about it, and there's a footstoots clause, and this is not one of those normal CPA type of agreements, you may find that the seller has protection to say, well, sorry, you bought it footstoots. I didn't know about those things. And, and unfortunately you took on the risk. So the risk sits with you, right? And that's unfortunately how footstoots applies, how defects apply, and whether somebody knew about the defect or not. I did hear in the question fraudulent COC, so that starts now swaying the facts a little bit. So now there's a fraudulent COC. Fraudulent implies there was something wrong. I knew there was something wrong. I paid someone anyway to get it done, but it's not worth the paper that it's written on. Now you start going, hold on, wait, that's not really a defect. That's a lie. That's inducement. So again, yes, the purchaser would then have recourse because they were lied to. Again, it's fraudulent behavior. They would be able to claim damages. They'd be able to potentially cancel the agreement and set it aside. This sounds like quite a large agreement. So setting it aside might be an option. Only downside is trying to get the purchase price back from the seller. And that's why we find our purchasers would typically rely on suing for damages, also known as the amount, the cost of the repairs. Because that's probably the only recourse that they're ever going to come close to being able to get. So Nick, I think this is a golden opportunity to then, cross that bridge into professional liability, maybe.
Yeah. So the other interesting part about this particular question, and specifically where the writer-in has asked about, is the PPRA and liability for the agency itself. Now, what is interesting about this particular circumstance is there seems to have been some conduct by the agent where they acted in an agent's capacity, even though in this particular case they were the seller. So the property seems to have been advertised from on an agent's website, and then the details for the agency as were filled in on the particular OTP in the circumstances. What changed in this particular circumstances where there was a commission payable in terms of the OTP, that was actually crossed out. So no commission was payable in terms of this particular transaction. And that does change something, quite a lot in terms of this particular transaction, because now it calls into question, well, this particular person was a seller and they happened to be an agent at the same time, but they weren't receiving remuneration for their conduct as an agent in this particular transaction, okay, because no commission was payable. And in the circumstances, it can stand to be argued that they were simply a seller. Yes, it was advertised through an agency. Yes, in terms of where an agency's details were, it was inserted on the particular documents in this transaction, but there was no remuneration payable. And this is, I think, where our writer-in has a problem, because they've obviously gone now to the agency, and the agency says, well, it's not our problem. They were obviously acting in their personal capacity, because from an agency's perspective, they didn't receive remuneration. It's not part of the work that they've done, as far as they can see. So what our writers asked is, does the PPRA have some scope in this particular transaction? Will they be able to facilitate, a resolve to this particular problem? And I think, what Bruno has touched on for damages, this is our normal process of going through court. And it's the reason I think we've gone to that first is that's very clearly a remedy which is available to this particular writer. When it comes to the PPRA, there are some difficulties because remuneration is not payable. This is basically the trigger point at which the Act sort of says this is the conduct, you know, you're not entitled to perform the functions of a property practitioner and receive remuneration for it. So the question comes in, well, if they weren't receiving remuneration, were they really performing those functions? Or, as in this transaction, were they just, you know, it's a difficult question. And to be honest, I don't think, because the remuneration is wanting in this particular transaction, I think that the PPRA is not going to have the requisite jurisdiction over the particular transaction to do anything with it. There may be, as Bruno pointed out earlier, this is a very factual question. This is something that needs to be assessed on its merits, and there may be, you know, in the emails or the correspondence between the parties, there may be something that can sway a PPRA in a different direction. You know, if official documentation is being sent out not by this particular seller, but by someone else who's employed in the company, this is indicative of the company functioning as an estate agent in the particular transaction, and that might sway, you know, the whole transaction differently. But I think, Bruno, you were very good in pointing out this is a factual assessment that has to happen in light of all of the transactions, and unfortunately, you know, we obviously don't have that at this particular point. It's really something that you would have to go to an attorney to assess the nuance of the particular case, what exactly happened in the transaction, to see whether this does fall within the realm of the PPRA. And remember, irrespective, even if the PPRA is not, you know, it doesn't fall within their realm for whatever reason, and it's just going to be treated as a straight sale from a seller to a purchaser. As Bruno's pointed out, you would still have that remedy potentially in front of the court, depending on the content of your particular contract. So at the end of the day, it's a very complex it's a very complex situation, and you know, we discussed beforehand, all of these particular transactions are very, very complicated things. They depend highly on what happened and the party's intention, and specifically, you know, the intention of the purchaser in the circumstances. Would they have entered into this contract if they had known the facts of the situation? And there's a very big, you know, there's a distinction in this particular transaction, which we don't know from the writer in, is, would you have entered into that contract if you had known about the defects, or were you entering into the contract because you believed that there was an agency backing the particular transaction? And what was your intention with both of those things? That would be something that has to be distilled, and might be the sticking point to say to a court, look, court, I need a remedy because this particular thing wasn't you know, advised to me at the point of entering the contract. But it's very much a factual thing, and something which would require a lot of assessment before you could go forward.
And even from a hypothetical perspective, if you assume certain facts, that's the thing. Is it a PPRA thing? Well, if this guy actually came across constantly saying, "Oh, but I'm an agent, I'm an agent, I'm an agent," yes, you might not be able to hold the agency responsible because they had no idea. That's also a factual thing, like you mentioned. Oh, was there an email from the agency? Because that would be different. But if this guy went around and tried to play himself out as an agent, building up this trusting relationship with you, because now you believe this guy because he's some kind of professional, and it turns out that he only did it in order to sell his property easier, it could be a professional issue that the PPRA will deal with. So even the range of recourse differs materially depending on the facts. So PPRA might be able to do this or that, depending on how deep this guy actually went to induce you to get into the contract. So yeah, it's a very, very detailed, like hour-long magnifying glass sort of thing.
Yeah.
Absolutely. Okay, so absolutely. So I think thank you, Nick and Bruno. With the information that we did have, you guys have done a wonderful job in trying to give as best answer as possible. But as both you guys say to Mr. or Miss Anonymous, please reach out to us specifically. You have emailed SSLR. So maybe just do a follow-up, have phone calls, then another email, or they'll reach out to you and then actually have a consultation. And let's, I would encourage us to actually spend some more time investigating it, asking more questions, we get some answers, and then we'll find the best sort of route for recourse.
Sure, sounds good.
Yeah.
Happy.
Yeah, thank you guys, and I will see everybody again next week.
Cool, thanks so
Perfect.
much.
Thanks, guys. Have a good week.
You too.